Okay. So hearsay within hearsay under Rule 805. The attached statements contain transaction entries originally made by third parties.
Ms. Lakin, I'm going to stop you right there because I've heard that argument before. That argument is misplaced. It's relying on the Texas rules of evidence, which do not apply in justice court cases for debts. That's why when I started the docket, I highlighted the rule of civil procedure that this falls under. So anything that you're referring to with the rules of evidence is not applicable in justice court because they don't apply. So do you have any other arguments that aren't based in the rules of evidence? Because you're right. If you were in county or district, cool, you've got a claim, but you're not in those courts. You're in a court of no record, justice court. So rules of evidence don't kick in. What other objections did you have?
First, improper notice.
It's not improper. That's what I'm saying. You're here, Ms. Lakin. Clearly you do know. You don't win on a technicality like that.
Hearsay within hearsay under Rule 805. The attached statements contain transaction entries originally made by third parties.
Ms. Lakin, I'm going to stop you right there because I've heard that argument before. That argument is misplaced. It's relying on the Texas rules of evidence, which do not apply in justice court cases for debts.
All right, guys, buckle up, because this woman walked into a Texas courtroom with a stack of objections she thought were bulletproof. Hearsay, authentication, rule numbers memorized. Every one of them real. Every one of them useless. Because she was standing in the one court where those rules do not apply. And the judge was about to tell her exactly why.
Next is 25102, Synchrony Bank versus Nicole Lakin. Do I have someone here on behalf of Synchrony Bank?
I am Shanae Banks for Rostrum.
Good afternoon, or good morning, Ms. Banks. Do I have someone on behalf of Nicole Lakin?
Yes, here.
Good morning, Ms. Lakin. Thank you for being here. All right, Ms. Banks, how much is the plaintiff? Now, Ms. Banks, I see that we still had a pending plaintiff's motion for summary judgment, but as we are all here, it may be kind of a moot situation. But why don't you tell me how much is plaintiff seeking?
The total amount is $5,059.87 plus cost of court.
All right, and then are y'all seeking post-judgment rate?
No post-judgment interest.
Nope. They wish to waive that. All right, and then is Synchrony the originator of the debt, or did they purchase it?
Synchrony is the originator.
Is this one of those where it was a GE Capital and they switched names? Or was it Synchrony all the way?
Let's see here. I'd have to look and see if that's what happened. Now, from my understanding, we were here. Did you guys get our motion for summary disposition?
We did. That's what I said, Ms. Banks. It is still pending before the court. So if you're giving me your information, it may be that is granted. But Ms. Lakin is here, so it's kind of all at once.
Okay. Just checking because I saw some type of error or something.
Synchrony Bank takes the floor first, laying out a balance of $5,599.87 on a CareCredit account they originated themselves. Lake immediately tries to redirect, asking the court to define the scope of the hearing and listing 3 pending matters. The judge cuts through it. No counterclaim fee paid meant no counterclaim ever existed.
No, I'm looking, but we're here, right? And Ms. Lakin has said that she disputes much of it. So since we're here, Synchrony is the originator of the debt. Looks like it was a CareCredit card originally?
Yes.
Okay. I wonder if y'all gave me the last statement. You gave me a whole bunch of them. No? Yeah. All right. Good morning, Ms. Lakin. Thank you for being here. Ms. Banks is representing Synchrony Banks. They're here on behalf of CareCredit, which is the originator of the debt. And they said there's an outstanding balance still of $5,059.87. So, Ms. Lakin, is there an outstanding balance on that credit card?
Your Honor, before we proceed, may I respectfully ask the court to clarify the scope of what today's setting is based on even what you just said about it originally being CareCredit and such. My notice simply stated hearing. I just want to be prepared to address the correct matter. There's 3 matters currently pending. My motion for reconsideration of the denial of the motion to compel arbitration, my answer and counterclaims, and my response and motion to strike plaintiff's discovery.
Ms. Lakin, did you pay the counterclaim fee?
I don't know what that is.
You did not. And since you never paid the counterclaim fee, your counterclaim was never filed. So that is denied as a matter of law. Today, we're here wholly about whether the plaintiff can prove that you owe money outstanding on a credit card debt. That credit card debt was created with Synchrony Bank, who is the petition of the credit. Synchrony, the bank, used a company called CareCredit. I'm going to show you a copy of the statement.
The judge lays out the entire framework in plain terms. Under Texas civil procedure, the plaintiff needs only prove ownership, default, and an outstanding balance. No original signed agreement required. 60 pages of affidavit and statements already satisfied that. Lake is told exactly what would save her, and instead, she objects to the proceeding itself over an arbitration motion already denied.
So the plaintiff says you took out a credit card through Synchrony Bank, and the brand name they used was CareCredit, but you made your payments to Synchrony Bank, which is why you're being sued by Synchrony Bank. And Synchrony Bank provided me 60 pages of affidavits and evidence showing that they sent you all these bills and you made payment on all of these bills until there came a point where you stopped paying. And their position today is that when you stopped paying, the amount outstanding to you is $5,059.87. And this is the evidence they're showing to support that. Under the Texas Rules of Civil Procedure, the plaintiff need only show me 8 specific things: that they currently own the debt, that the debt is still due and payable, that the debt was opened by the defendant, that the defendant defaulted on the debt, and that there is a right for them to sue. After they do that, they can use documentary evidence. Texas Rules of Civil Procedure say that evidence need not include the original agreement where you originally signed up for the debt. They do not have to show me the very first time you applied for the credit card. The state law says that's not necessary. They need only show me that you did make payments on it, and they've given that by giving me all the statements. They need only show me that there is a balance outstanding, and they can do that with testimony or with pieces of paper. That's what that affidavit is. Ms. Lakin, the question today is they've met their burden under the law to win their case. In order for them to not get the full amount of the judgment, you would need to present evidence today that you have made payments toward it, or that you are not the Nicole Lakin that's being sued. Perhaps that you can show, and I don't know how that evidence works. I've seen other versions, right? Like, it is not you. You have been a victim of fraud, and then, people have brought in evidence of the fraud. So the question I had is, are you the Nicole Lakin that opened up this credit card with Synchrony Bank for CareCredit? Yes or no?
So let me know if Your Honor.
Then comes the twist. A fee had been paid by her husband back in February. The counterclaim was alive after all. The judge asks one question: what is the cause of action? Lake cannot answer it. She falls back on improper notice, and the judge dismantles it instantly. She is standing in the courtroom. Notice was received. The hearsay argument returns and dies the same way.
I object to the proceeding to evidence while my motion to compel arbitration remains pending, and I preserve my right to.
Ms. Lakin, the motion to compel arbitration was denied, and I'm not giving it a rehearing. If you're unhappy with that, you can appeal, but we are still proceeding with the hearing today. So the motion to compel arbitration was denied. Okay? Your motion for counterclaim had to be denied because you did not pay the counterclaim fee. If you want to appeal, you might still have the opportunity to file a counterclaim, but a counterclaim requires payment of a fee. All lawsuits require payment of a fee.
Your Honor, I do have a finding on this one. I sent you a screenshot because I see a fee was posted from a Samson for the defendant. Udu Sanya Sampson paid a $54 counterclaim fee back in February.
Correct. That's my husband, Samson Odusanya. That's me.
So it looks like it was paid.
What is your counterclaim for, Ms. Lakin?
Hearsay, lack of foundation, lack of personal knowledge, improper self-authentication, and improper notice under Rule 902.10. And I would love to be heard on that.
Ms. Lakin, what's the cause of action?
Cause of action. Can you help me understand that better?
I can't, because I'm the judge. I can't advise you about, if you filed a counterclaim, you have to say that they have broken the law or committed a crime against you that entitles you to punishment or entitles you to something. What have they done wrong?
Correct. Thank you, Your Honor. So first, improper notice.
But you're here, so that's not true. That's my point. You're here. Clearly you have notice, and you filed a counterclaim, so you definitely are aware. So that part is moot. What's the rest of the claim?
Well, improper notice.
It's not improper. That's what I'm saying. You're here, Ms. Lakin. Clearly you do know. You don't win on a technicality like that. You don't. So move to the next issue.
Okay.
Because they have proven with evidence that you open up a credit card, someone named Nicole Lakin with your address hasn't paid it. The question I have is it fraud or do you owe some money? And if you owe some money, how much money? Because that's the dispute we can get into, is how much money is owed. But they right now, with their evidence, shown and established that you owe at least $4,000.
So what we're talking about here as well is SEC filings, and I can get to that. The exhibit, the affidavit, the evidence, what they're sharing deserves little to no weight for 3 reasons. May I share?
What?
Okay. So hearsay within hearsay under Rule 805. The attached statements contain transaction entries originally made by third parties.
Ms. Lakin, I'm going to stop you right there because I've heard that argument before. That argument is misplaced. It's relying on the Texas rules of evidence, which do not apply in justice court cases for debts. That's why when I started the docket, I highlighted the rule of civil procedure that this falls under. So anything that you're referring to with the rules of evidence is not applicable in justice court because they don't apply. So do you have any other arguments that aren't based in the rules of evidence? Because you're right. If you were in county or district, cool. You've got a claim, but you're not in those courts. You're in a court of no record, justice court. So rules of evidence don't kick in. What other objections did you have?
One moment. Okay. With great respect, Your Honor, Texas Rule of Civil Procedure 500.3E provides that the Texas rules of evidence apply in justice court unless the court formally relaxes them by order.
They do not. You have to seek it in advance, and I've not had it sought. They do not apply today, Ms. Lakin.
Okay.
They have to be asked in advance because parties can't just have it sprung on them at the last minute. If you had sought it in advance, I might have granted it, and then we would be all bound by it. But it wasn't, and therefore I can't do it at the last minute. That would be unfair surprise. The same thing would be true if Ms. Banks tried to do that to you. I would say no to her as well. It's about fairness.
Okay.
What's the next one?
Can I respectfully ask the court to apply rules 803.6, 902.10, and 901 as written?
No, I can't apply the rules of evidence at the last minute, Ms. Lakin.
Okay. No, I understand. Thank you. Got it. Learning a lot.
It goes to fairness, right? It would be wrong to unfairly do that to either side. But if you wanted to do that, call a lawyer and they can explain to you what your options are, like on appeal. Also, if you're in another court, you're going to be in a different set of rules anyway.
Okay.
Go to the basics of the claim, Ms. Lakin. Did you open up the credit card? Yes or no? Ms. Lakin?
Yes.
Okay. Did you finish paying off the full debt? Yes or no?
I did not.
Then there's a balance in your name outstanding. How much, to your knowledge, is the balance outstanding?
Repeat that, please.
You said that the balance remains unpaid. To your knowledge, what's the outstanding balance on the credit card?
I don't have any outstanding balance. I don't owe any longer. So for me, I move for a directed verdict, judgment as a matter of law in my favor. The plaintiff has rested without admissible business records affidavit supported by a witness with personal knowledge, without authentication of the cardholder agreement, and without any evidence resolving the chain of title issue raised by plaintiff's own SEC filings. Plaintiff has not met its prima facie burden, and I respectfully ask the court to enter judgment in my favor.
Court overrules. It's going to be a judgment for plaintiff today. $5,059.87 plus cost of court. Judgment is going to enter a 0 for post-judgment rate. Plaintiff is waiving that. Plaintiff established their case sufficiently under the Texas Rules of Civil Procedure. They provided a sworn affidavit. They provided original creditor statements. Defendant admitted that she opened up the credit card, admitted that there was a balance outstanding. The only dispute I heard was about the balance itself. The defendant, you've offered no information to dispute what the plaintiff is otherwise sworn to under an affidavit that fulfills the requirements of the Texas Rules of Civil Procedure for debt cases in justice court. I checked it, and they've given me all the original creditors as well. Ms. Lakin, you have 21 days to appeal. We will send you immediate information about your right to do so. If you wish to appeal, but you can't afford the appeal bond, because there's going to be an automatic appeal bond, you may still be eligible to appeal for free if you qualify for an affidavit of inability. And we will send you that information. You have to fill that out and give it back to the court. Okay? Ms. Lakin, can I answer any questions about the appeals process?
No.
All right. Ms. Howard or Ms. Banks, any questions?
No, ma'am. Thank you.
All right. All parties are excused. Thank you. I'll have a good morning.
Lake makes one final play, citing Rule 500.3E, arguing the rules of evidence apply unless relaxed. The judge reverses it. They must be requested in advance, and she never asked. Then the two simple questions. Did you open the card? Yes. Did you pay it off? No. She still moves for directed verdict. Overruled. Judgment for the full amount. Like the video, subscribe to the channel, and we'll see you in the next video.